All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge. Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements here, talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know, but you don't have the first clue when it comes to things, and you talk about that. And so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I don't want to state also that if it was recorded, that we would say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. Which is what is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without
all right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. You, the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did, well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
Mr. Gazicki, you are so released.
Yep. Okay. Go!
Will you hand me my scream box? Now go. Freak.
This is case 242497FY, People versus Jasmine Buddha. Ms. Buddha, could you state your name for the record, please? Ms. Buddha, you are still muted.
Yes, my name is Jasmine Tanae Boda.
Okay, Ms. Buddha. And counsel.
Kim Michon, Neighborhood Defender Services, P59167, on behalf of Ms. Boda, Your Honor. Today is the date and time set for a preliminary examination. Ms. Boda is on Zoom. I'm here in person. I would ask the court not to capious her, Judge. The last time we were scheduled for court, it was completely my fault. Unfortunately, my mother had a medical emergency and I had to fly to California.
Life happens.
And the poor woman came in from Minnesota. We haven't had a chance to talk since then. I just flew back the other day. I'm asking the court to be gracious enough as to not issue a bench warrant for her arrest, please, and thank you, sir.
So, Ms. Boda, I was going to issue a bench warrant because today was the exam date and you were supposed to be here in person, but you're not. I'm not, based on what Ms. Michon is asking me, I'm not going to issue the bench warrant. So I am going to have to, first off, there was an offer that was made. That was my understanding. The court was apprised of an offer that was made. Ms. Boda had the opportunity to speak with Ms. Michon in a breakout room and discuss that new offer that had came in. Ms. Michon, was there any resolution or progress related to that offer?
No, Your Honor, but for the record, our office did submit a letter to the gun committee with all of the documentation that Ms. Boda was gracious enough to send me. We did receive an offer of count 1 being reduced to a disorderly person, a misdemeanor, and count 2 being reduced to a attempt resisting and obstructing, also a misdemeanor. Those have been conveyed to Ms. Boda. At this time, Your Honor, based upon our conversation, I believe there has been a breakdown in the attorney-client relationship, and I believe Ms. Boda would be better off with an attorney that she's going to listen to. And therefore, we respectfully request this court withdraw us from the case.
All right. So I'm going to first note for the record that it appears that Ms. Michon has done everything legally and physically possible that one could do as a defense attorney in the situation. 2, you've had conversations and you're saying basically that the sound legal advice that you have been given has fallen on deaf ears.
That's a fair assessment, Judge.
Okay. And there seems to be a lack of communication between you and Ms. Boda. Is that correct?
That's fair.
Okay. Ms. Boda, I'm going to appoint you a new attorney. You have 3 options.
I have not been able to speak to her outside. I've multiple times emailed and have no response. I would like to talk to a lawyer outside of this situation. I decided not to come because I'm saying when I came last time, there was no money. I don't have any money. I was broke when this situation happened to me.
Okay. So here's the thing.
I'm not trying to go against her. I trust this, but I was not trying to resist anything. I was not understanding. I needed medical attention. I was having a panic attack.
Ma'am, please don't talk about the case. Okay.
Yeah, you do have a right to remain silent. Anything you say on the record can be used against you. Not to mention that anything that you and she talked about, if you go ahead and talk about it in the open, in public, it waives and destroys your privilege that you have for that. So I'm just saying, anything that the 2 of you talked about, just don't talk about it. So basically, here's what I'm going to do. You have 3 options. 1 is you can hire your own attorney. 2, you can represent yourself because you have a constitutional right to do that. Or 3, I can appoint you another attorney. And you'll have the opportunity to talk with that attorney. Which of those 3 options would you prefer? Because I'm going to release Ms. Michon.
Thank you, Judge.
But which would you want me to appoint you another attorney? You stated that you didn't have money. I don't know if you meant money to travel or just money in general. If you can't afford an attorney, one would be appointed to you by the court of public expense, not a problem. would you like me to appoint you another attorney? Would you like to hire your own attorney, or would you like to represent yourself? Which would you like to do?
At this point, the only option seems to be I would need for you to appoint someone.
So you want me to appoint another attorney for you?
That is the best option.
Okay, sure. That's an honest answer. That's all I needed to know is which way you wanted me to go. What I'm going to do is I'm sorry, I'm losing my voice. What I'm going to do is for the benefit of that attorney and for the establishment of a sound constitutional foundation and a good working foundation, I want to make sure that that attorney is as a private thing as possible. So I'm going to set this for a probable cause conference so that they have the opportunity to meet with you, meet with the prosecutor, look at the file, and then we'll set.
Can I speak to the lawyer one more time? Ms. Michon, please.
I've already released her, so she's no longer your attorney. So anything you say to her would not be under attorney-client privilege. So because of that, we're going to protect your constitutional rights, because it would be you making statements to somebody who's not your attorney, who then could be subpoenaed and called as a witness against you. So I don't want to put her in that position or you, okay? So I'm going to set this for a probable cause conference, and that will be by Zoom, not in person, by Zoom. And that way you're going to be able to know who that is. So we're going to set probable cause conference. I don't know if we're going to have to go outside of NDS.
You will, Judge.
So we're going to have to go through other means. So I'm going to give that a couple weeks so that my clerk isn't like trying to figure out where to go. So your probable cause conference, just hang on. Your probable cause conference is going to be on the 27th of January. Okay.
I have to attend the birth at that time. I have a woman who's due on the 26th in California. They have already paid for me to fly. I'm not available on the 26th, on the 27th.
All right, then I'll make it earlier. I'll make it the 20th.
Or not.
Actually, the 22nd. It's easy to make a 7 into a 2, so that also helps. All right, so the 22nd will be your probable cause conference. And that'll be at 1:30. That's going to be by Zoom. And then we're going to set the exam date. So you say you're flying out to California on the 26th?
He's due on the 26th. I'm trying to leave Minnesota. My birthday's on the 19th. I'm trying to leave around the 18th and hope that I can attend the birth. I just don't want to be wrapped up.
All right, so I guess I'm confused, because I was going to set something for the 27th. You said something about leaving to go or something on the 26th, and then.
Well, she's due.
No.
The baby is due on the 26th, and I'm a doula, and so I don't know if I would be in labor during that time, or if I would be working, is what I'm saying.
You're saying that you are pregnant and your baby is due on the 26th?
No, I am a birth coach and a doula, and I have a birth that is due of another woman, and I've been asked to attend it. Her due date is the 26th of January this month.
She lives in a different state?
Yes. So that she hired me to attend her birth, and I go and I wait and I do work with herbs and stuff to help her attend the birth. So,
okay, well, so you're leaving on, when are you leaving to go to California?
I haven't purchased my ticket. The goal was maybe about the 18th or the 19th.
Sure. All right. So you're going to leave on the 18th or 19th. Here's a cool thing. The internet works in California. And so you can sign in to Zoom. You're going to have to sign in, if you're using California time, you're going to have to sign in 3 hours early. So instead of 1:30, you're going to probably want to sign in, not at 12:30, not at 11:30, but at 10:30 California time. Because that way you'll be here and it'll be 1:30 here and you'll be ready to go and you can talk in by Zoom. Not going to miss anything. You're still going to be there on the 22nd. That doesn't sound like it's going to be the baby's due date anyway. So you got some wiggle room there. It's right in the middle with nice, maybe that lull, that little bit of time there. 22nd. It's not going to be take all day, because you're going to be meeting your new attorney. You're going to be talking with the prosecutor already has the offer, and I'm not sure if that offer is going to stay. When you don't take an offer, it could always be withdrawn, just saying.
Well,
I don't know.
I just,
Just hang on.
I will ask them to keep it open for the next attorney.
Sure. And Ms. Michonne is going to make sure that, or she's going to ask it, and it's not on her, it's on them. If they want to withdraw, they can withdraw. So 22nd, probable cause conference. Baby's due date is the 26th. So I'm going to set the exam for the 10th of February. Said, I don't know. I mean, I know I was late. I know my kids were all late. They weren't late like 2 weeks, but so I don't know. So the 10th should be a good date for you. Should be a good date, okay?
Thank you so much.
So you're gonna have to come, maybe you come from California right to Michigan, or maybe you stop in Minnesota and then come to, I don't know. But on the 10th, I'm gonna set it for the 10th. Now, that doesn't mean it's written in stone. If your new attorney needs a little bit more time, whatever, so I don't know.
I need someone
just
to
saying-
review
I'm just
the
saying, I'm setting a
documented
date. I'm
evidence
just
at
setting a
least.
date for you,
Jesus
okay?
Christ, come there alive.
Excuse
And
me.
I will make sure that it as a discovery judge.
Right, and Ms. Michonne is all the discovery is gonna be forwarded to the new attorney, so, all right?
Thank you so much, Your Honor.
All right, so, Ms. Michonne's motion to withdraw is granted.
Thank you.
The probable cause conference is set for the 22nd of January at 1:30 via Zoom. The new appointed attorney will be representing Ms. Boda. If they can reach out, Ms. Boda, all your contact information is still the same, right?
Yes.
Ms. Boda, all your
Yes, Your
contact.
Honor.
There you go. And we're gonna mail out everything. Now, are you gonna be able to receive? And so if you want to write these things down, because we're gonna mail them all to your Minnesota address. But if you're in California and you don't have a forwarding address, you're gonna get notices. So I'm just telling you right now, the next date is January 22nd, 2025 at 1:30 via Zoom. It's that same Zoom number, the 555-993-6538 or 34. And just like you did today. Then the next date after that is going to be February 10th, 2025 here at the courthouse.
And very fortuitous, Judge, your prosecutor just walked through and I did confirm with her. She will hold that offer open for the next attorney.
Ms. Boda, the next attorney will still have that same offer to work with, to talk to you about, okay?
Thank you, Judge. Lovely day to you and your staff.
All right, so Ms. Boda, you go ahead and sign out. Best of luck on your travels and birthing experiences and all the good stuff, all right? Have a good day.
You too.
-36930 is called the state of Texas versus Caleb Charles Noel. You're Mr. Noel. Present with Mr. Grove, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 23rd, 2020, in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery with the use and exhibition of a deadly weapon, namely a firearm. Do you understand what you are charged with?
Yes.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Take off your hat, sir. Thank you very much. An agreement has been reached in this case that you would be pleading guilty and sentenced to 10 years in prison, would run concurrently with a burglary case, to assaults, other things out of Harris County. Is that your understanding of the agreement?
Yes, sir.
Okay, so this is all run together with 2 other aggravated robberies, a burglary, 2 assault cases, all of that?
Yes,
10
sir.
years?
Yes.
Okay.
At one point in time, Your Honor, I had a probation offer on the table for reasons detailed with the case, but in light of his getting into trouble with Harris County, the defense and I worked out this, and I feel like it's appropriate, Judge.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty?
Yes.
So you're pleading guilty voluntarily and because you are guilty.
Volunteer.
And voluntary and because you are guilty. I'm going to follow this agreement, if nothing further, and I'm going to find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of aggravated robbery as alleged in this indictment. I am following this agreement. You are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 10 years. Also, an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense will be placed into the judgment in that case. Do you understand what has happened today? Anything else?
Oh, yeah.
That is all.
Thank you, Judge.
Come on up, please. You're Betty Handy. 23-41397 is called. There is a motion to revoke probation that was filed in September of last year. Mr. West is here representing you, and it alleges essentially that you failed to report to the probation office July, August, and September, failed to provide verification of performing community service hours, and is behind in different things, money-wise. That is part of all of this. You were placed on probation on April 4th of 2023 for 5 years for injury to a child. And that was state jail felony, correct, everybody? Yeah.
Yes.
All right. What did you, there's a motion pending. Probation is here and state's here and defendant's here, defense attorney. What are we going to do?
Your Honor, I think Mr. Haney wanted to explain to you what happened when I don't want to use the word absconded, but stopped checking in. She thought she was still checking in. I just want to let her explain kind of what was going on so the court can decide what to do. We were going to ask the court to abate this, hold this, and let her back on probation to see if we can catch up.
Okay, go ahead.
Well, actually, they swear in so she can testify to the court.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. This is kind of odd.
Shouldn't she enter a plea?
I guess, yeah, you're right.
What do you want to do?
We should go ahead and enter a plea. You're right. She needs to enter a plea first.
Okay.
Yeah.
All right.
Gotta have
The
myself
motion to
there,
revoke unadjudicated probation that's been filed. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this in motion to revoke probation alleges that on April 4th, 2023, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of injury to a child. Is that true?
Yes, sir.
Allegation 1 states you failed to report to the probation office for July 26th, August 22nd, September 12th, 2024 in violation of your probation order. Is that true or untrue? That's not true. Okay. Number 2, you failed to provide verification of performing community service hours as required. Is that true or untrue?
That's true.
That's true?
Yes.
You failed to pay court assessed fees as directed. And number 3, and as of September 12th, 2024, you were in arrears $1,345. Is that true?
Yes.
Were you able to pay that?
I did make the payment. My last payment was a $300 payment in June.
Okay. Well, why haven't you made payments since June?
I was, they had me on a payment plan with my rent. I was paying $1,000 a week, which, with the job I was working up north, I was getting paid about 15, but I also paid child support too. And I was behind on child support, so I was making sure I was paying that up too.
Were you able to pay this
No, sir.
because of other obligations? I need to read that.
I'll just glance at her real fast, Judge. I'll give it right back to her. Thank you, Judge.
So you're saying you're in arrears, but you weren't able to pay it. This failure, do you understand that a plea of true to one or more violations of probation is enough
Yes.
to grant the motion to revoke probation? Your probation can be revoked and you can be then found guilty and sentenced no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today to that allegation,
Yes, sir.
failing to perform community service hours as required?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let's talk about this number one, this failing to report, because there are certain more serious obligations of probation than others, and committing crimes on probation, while on probation, that's serious. But failing to report means if you don't report, you're not really under supervision. We can't supervise you. We're not the ones who are going to go out and find you. Your obligation is to come and report as required. If you don't, you're not really on probation anymore. And then that means that you're facing the consequences of revocation. And we're going to figure this out. So let me ask, was she on a monthly plan or every other week for probation? Ms. Campos?
She's reporting monthly.
Okay. Is that right? You were supposed to
Yes, sir.
once a month? So you're saying on July 26th, August 27th, and September 12th, 2024, you did report on those days. It says you didn't.
No, sir.
You're under,
Didn't.
you didn't. Okay. Did you report? Why? What, were you supposed to report on those days?
No,
Why
I
not?
don't, I'm not sure. I didn't know.
You should know.
Well, I was,
I mean, you've been on probation, you were on probation for over a year, and there was a sequence of
well,
normalcy.
Can I ask you some questions and lay that out? Because I think it's.
I'd like to know.
Yeah, that would, I think if I ask questions and leave it there, you would find out all those answers. I know exactly what you're looking at.
All right, go ahead.
Ms. Handy, you've been on probation for a while now, correct?
yes, sir.
Okay. But sometime in July, you stopped reporting in person. Is that correct?
Yes, sir.
July of what year?
This year. I'm sorry. No,
There-
actually last year, 2024. I know.
24.
Why?
Well, I was, last time I reported was in May. And my probation officer, she had told me,
Who was that?
Miss Officer Lee. She told me, I told her I had a contract for my job to go 3 months up north in Montana. And she had wrote it up and I signed it. And she told me the next time I had to report was in July the 25th.
6.
The 26th. And I had emailed her because me and her were contacting each other through email. And I emailed her and told her I wasn't going to be able to come on the 26th because my flight got delayed. I was up north and I wasn't supposed to come back until September the 8th. And I just never.
Wait. You're jumping. You weren't supposed to come back until September 8th of 2024?
Yes.
Who said that?
That's what my contract had said on my paperwork.
What?
But she told me to come and report July the 26th or 27th. And I had emailed her. I told her my flight got delayed and I never got a response back. So, and the service was bad up north. I ended up getting a new number. I emailed her my new number. And I also emailed her the paperwork showing like my fees of why I wasn't able to pay my fees, but I did pay $300 because of my rent. I was looking at eviction notice and they put me up a payment plan to pay $1,000 every week.
Who's they?
My apartment where I was living at.
So let me ask you a question. So you say
So, I didn't understand this. You can explain it. Your flight was delayed. It's been delayed ever since you got arrested then? Your flight was delayed for months?
So I didn't come back until
Come on.
September
Oh. When?
the 8th. I didn't know that I had a warrant for my arrest or anything.
Well, you think we're going to just forget about you?
No, sir.
What'd you think?
I just didn't follow.
Yeah, but your flight was delayed.
That was
It's
in
been
July.
delayed for 3 months?
It was in July. I was
No.
waiting on her to respond to me back. She never
Who?
responded. My officer.
So it's your officer's fault.
She never.
Is that your, you have the obligation under law. You have an obligation that you go to jail on if you don't follow, not her. That's your obligation. We have 5,000 probationers. You think we're supposed to, I think we were being kind enough to allow you to go to Montana to work. But then we can't keep up with you when you're 2,000 miles away. Except by following the appointments as required. And your flight was delayed. Okay, your flight was delayed. That's your excuse for July 26th. When did you come back home?
September 8th.
So August. So 2 months. It took you 2 months to resolve the delayed flight.
No, sir.
That's what it sounds.
Because I usually get a text message saying, when is my next appointment to go to come to report. I always get a text message.
Once again, 5,000 people, we can't be finding them. You're held, you're responsible. And the most important requirement is reporting. If you don't report, you're not on probation. You're not on supervision. Because how are we supervising? We cut you some slack and allowed you privilege to go up there, but it's your obligation to be coming down here responsibly and regularly so that we're keeping in contact with you face to face. That's the way it works for everybody. You're not going to be treated any differently. But generally, here's what we can do to people. We're going to call it the Betty Handy rule. From now, I can say, you know, you want to go work somewhere? No, because this thing came up and Betty Handy said had all kinds of excuses. She went to Montana and she wouldn't come back responsibly. And we're not going to let that anymore. We're not going to let that out of the bag anymore. Everybody's going to have to stay in Jefferson County. Even if you don't live in here, you're going to end up staying in Jefferson County so we can keep an eye on you. 5,000 probationers. How do you think that would work? It'd be chaos, wouldn't it?
Yes, sir.
Because there's a lot of people who don't live here. A lot of people don't work here. But you still have to report here, and that's your responsibility, or else you're not reporting, or you're not on probation. And it's what's good for you is good for all 5,000. You're not an exception. From probation, tell me, what's your side on this? What do we know? About
Judge,
not reporting?
she did find the travel permit that was generated back on May 29th. And Miss Handy did sign that. It does say in writing that she had the right to go to Montana, and that is through the date of July 15th. So it was approved by you as well as the probation office, but it doesn't alleviate the times and dates that she was supposed to have returned.
What happened on, okay, July 26th, she failed to appear
Yes, sir.
Yes.
from probation. She was supposed to see you?
Yes.
What was the excuse?
In July, I took over Miss Lee's caseload. She's saying that she was communicating with Miss Lee through email, but wasn't getting any response. If she would have called the front office or talked to her supervisor, they would have let her know Miss Lee is no longer her officer, and they would have gave her my contact information. She did get monthly texts from the computer system reminding her of her appointments, but if she updated her phone number by email to Miss Lee, I wouldn't have known.
So the department did provide her notice about the 3 dates that are in there: July 26th, August 22nd, and September 12th, right? And that September 12th date was an administrative hearing date, correct?
Yes.
And she never contacted any time through there?
Now that letter was actually returned because that address wasn't.
So you attempted to contact her through all the means that you were aware of, correct? And she made no contact with you in the months of October and November as well?
Hold on, back up. What was this about? It was returned. What was returned?
The letter to notify her of her.
Of the administrative hearing, right?
Yes.
Let me see that, please.
Sorry, Judge.
Okay. The letter was sent to 665017?
Yes, that was the address we had on file.
Where did you think she was at the time this was sent, which was
Well, she had permission to be,
August 27th of 2024?
I apologize, Judge. She had permission to be in Montana up and through July 15th. So it would be appropriate for the department to have assumed that she returned back to her residence here.
All right.
Because she would have been following your orders.
So she was only granted authority to leave through what date from the probation office?
Leaving June 17th, 2024, and to return no later than July 15th, 2024.
Okay. All right. Let's get, okay. July what, 15?
Yes.
Yes, Your Honor.
Okay, so
This is that.
that was the only authority that she had to return to this jurisdiction no later than July 15th of 2024.
Thank you, Judge.
Thank you. So as of July 16th, she was an absconder. Then, correct? She only had authority through July 15th.
If she stayed outside of Texas, which her statements today say she stayed in Montana till September, then the answer is yes, Your Honor.
When did we get in contact with her again after that letter?
Face-to-face contact with her at the jail.
Say that again.
I had face-to-face contact with her at the jail.
What date was that?
Your Honor, she was arrested on November 21st of 2024. So you would have seen her sometime after that. Do you know
Is that
when?
right?
Did,
Was that right? You were arrested on November 21st?
yes, sir.
Okay. So
I did.
July, August, September, October, November, 4 months, we were absconding.
Yes, sir.
Is that right, everybody, from the state's position? Is that what we understand?
If not 5 months, Judge. Because we go from July 15th to August 15th. I'm going to say at least 4 months, Judge.
And no other communication from her for those 4 months?
She may have contacted me. I believe I did tell her she had an active warrant for her arrest.
When would that have been?
The warrant was issued on October 2nd, so it would have been in between October 2nd and November 21st, 2024.
No, when did you tell her that, though, that directly that she had a warrant for her arrest? Do you remember?
I don't have the exact date.
Okay. Well, what did she say to you about that? Do you remember what her response was?
I just let her know that she needed to turn herself in.
Well, how long did that pass after that? About, any guess?
Well, she was arrested within a month.
Okay, arrested what date?
November 21st, 2020.
Okay, so that's the date. Where was she arrested?
Sure, at my home,
Where was that?
Western Crossing, Beaumont, Texas.
Okay, here in Beaumont. So you had been in Beaumont.
Yes, sir. Since September, yes, sir, I have been in Beaumont. I didn't know about the warrant until I called my probation officer.
What difference does it make? Why weren't you reporting when you were here in Beaumont?
It was, I'm not sure.
You know you had to report
Yes, I did. I was
monthly.
I didn't know how. This is my first time on probation or anything. I didn't know it. I didn't know about it. Like I knew about it, but I didn't think that I had to because my probation officer wasn't contacting me. I thought.
Oh, they had to go and get you and bring you?
No, I was contacting her, but I wasn't getting a response back. And we talked through email. Anytime we talked, it was through email.
Well, then you had, what she
didn't
said
know
was there was a warrant for your
I
arrest.
didn't know I had a new probation officer until I called the probation.
She said,
My
did you
bro-
hear what she just said a little while
Yes,
ago?
sir.
That she talked to you and said there was a warrant for your
brother
arrest.
told me that a police officer had went to my old address looking for me, and that's what made me call up to the probation office.
When were you going to delight us with an appearance? Since you had been here for a while now,
I had started,
when were you going to give us the satisfaction
started
of seeing you again?
I started working at Burger King because I was trying to make the money to get a lawyer, a paid lawyer.
So you knew you had to report you were avoiding coming in.
I was trying to gather money to get a lawyer, yes, sir.
Even though every day goes by, you were committing a violation. You were waiting to get a lawyer. That's your strategy in this, right?
Yes, sir.
Okay.
All right, let me ask you a couple more questions to my client. I have a few questions I've written down. Thank you. Sandy, why did you stay in Montana beyond July 15th?
I didn't know that I had to come back.
No, I mean, why were you staying there? I mean, what was going on? Why were you there?
I'm a nurse assistant.
Okay. My point is you were still working, correct?
Yes.
Okay. So you
I
continued.
was on a contract.
And did you let Miss Lee know that your work was going to be beyond July 15th?
Yes, I showed her the contract.
Okay.
I sent it to her email.
All right. And so you tried to make contact with Miss Lee via email several times, correct?
Yes.
Okay. No, she was no longer your probation officer or supervision officer.
I did not know that.
Okay. And did you check in? You did not check in person to probation officer when you got back to Beaumont. Did you ever send an email or any kind of notification to Miss Lee when you got back?
Yeah, when I was on my way back, yes, I did.
Okay. All right. Okay. So even though you weren't checking in person, you thought you were checking in because you were sending notice and communication to Miss Lee, correct?
Correct.
Okay. Now, you know today that Miss Lee had moved on and was no longer working there, correct? That was the wrong person.
Right.
Okay. If the judge was to let you continue on probation and see what's going on, you know that if you can't get in touch with your probation officer, to contact the probation department, correct?
Correct.
Okay. That was your mistake. You didn't think to contact them, correct?
Correct.
Yeah. Pass the witness.
I have no questions of this witness, Judge.
All of the testimony that has been given by the probation office today, was all of that true and correct? And it was as though you were under oath, so help you God. So your statements here for the court is that the defendant had been informed she did not have authority to be in, she had to report on July 26th, August 22nd, and September 12th, 2024, which she failed to do. And that she had been given notice of that from the probation office. She has admitted, Ms. Handy has admitted under oath for failing to provide verification of performing community service hours as required. She's been on probation since April 4th of 2023. How much community service hours has she?
She was assigned 400 hours. She hasn't completed any hours.
How many has she completed?
Zero.
Zero. Is that true?
Yes, sir.
You explain that.
Well, I pay child support and I'm also.
Can you explain that? We all have obligations, but this is an obligation that keeps you from getting convicted.
Well, I knew I had 5 years of probation. I didn't know I had to do it like right then and there.
That's not the understanding I have from my probation office. From probation, hold on. What is normal and customary for all probationers when they are received into probation? Are they told that they get to decide when they do community service hours, or is it a plan that's set by the probation office?
No, we encourage them to complete it as soon as possible.
Correct.
How much is it? How much did she have? What was her requirement?
She was assigned 400 hours.
Okay. And so here we are today, and it's 2025. So in a few months, you will be on probation for 2 years, and you have done zero community service hours, correct? So I know what Mr. West is asking for, to continue on probation. What does the state say?
What speaks well for Miss Handy is that her pristine record before this case arose. I mean, no other arrest outside of this. So I note that because it's disappointing that we're here having this conversation. I really felt like Miss Handy would be one of those that would learn her lesson and we wouldn't be having this. the facts of the offense itself warrants a state jail sentence simply because of the nature of it.
You're talking about injury to a child.
Yes, sir. And it's the manner in which that happens, as the court is aware within the PSI. The goal was to have her on probation and learn better ways to discipline a child. You hear her say today that she's underneath the child support order and that she's handling that. But Judge, just listening to her go back and forth on your comments and what the probation office said, it's clear to me that she's going to struggle to complete probation. So I guess I'm on the fence. Is why I started with telling you that about her record. I hate to give her a conviction, but I think she's really doing that to herself. I would recommend, because of the time frame and the absconding judge, revocation.
Okay.
And a light sentence.
From the probation office, this batterers intervention program that was ordered, which is the substance of the nature of this case that needed to be addressed. What has she done on that?
She did not qualify to enter and complete the batterers the FIT program. So what they did instead was anger management and a parenting class, and she completed both in 2023.
Okay. Something's been done.
That's big.
Where's the child now? Where's the child?
Lake Charles, and he was with his grandmother in Lake Charles.
That's been from the onset of the offense, Judge.
How long have you been in jail now?
I've been since November 21st, 2024.
47 days is what the system says, Judge.
All right. Anything else?
So I think you've had everything done.
Here.
Thank you, Judge.
All right, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegations 1 and 2 have been proven true by the evidence presented. And also, number 2, failing to provide verification performing community service hours was admitted to by the defendant, which is enough to grant this motion to revoke probation, revoke the defendant's probation. You can now be found guilty and sentenced up to 2 years in the state jail. Anything else to add by anybody?
No, Your Honor.
All right. I'm going to find that there is enough evidence to grant this motion for revocation. I'm going to defer I'm going to defer further action on this. A couple of things are going to be done. You're going to serve 10 more days in jail. That will be 60. And then I'm going to place you back on probation. You will see the probation office immediately upon being released. You will be following the terms and conditions of probation 100%. You will catch up on this community service that has failed, that you have failed to perform. There will be, I want to get updates from the probation office regarding the defendant's actions. And you need, okay, that's going to be served 10 more days. She's got 50. I mean, she's got credit for 10 days right now, but it's going to be serve additional 10 days.
I can modify that.
Okay.
Do you want a review date, Your Honor?
Yeah, I always do that. But I want you to move quickly on catching up with all the terms and probations. It's real simple. If we come back, this is held in abeyance. It's deferred, so it's over your head. If I find out that probation is not being 100% fully followed, We're going to pick up where we left off. It's that simple. Okay, now your probation is revoked. You're found guilty. You're sentenced up to 2 years in the state jail. So future is in your hands. Fix this mess. Okay, that is all. Mr. Rogers is charged in 24 CR 1697, aggravated assault with a deadly weapon. And you were facing up to 20 years in prison in this case.
Your Honor, if we get it one more time, we're working on trying to get him in the Veterans Court. He's a veteran, and I believe this qualifies for that. So if we get some more times, we can get that taken care of.
All right, who is Charletha Rogers?
My wife.
Okay. Where does she live?
3545 Richmond.
Is that where you live too?
Yes, sir. That's my address.
Well, he's not staying there, Your Honor. That's his address.
Well, that's what he just said.
Well,
That's where
he's
I
been-
said living. What does that mean? How can you live and not stay?
See, now
somewhere?
talk about that. He's been living with his mother.
Are you having any contact with the lady?
Yes, sir. We have
Yeah.
been talking, and we've been going to marriage counseling with through the CPS caseworker.
Oh, okay.
As well.
Somebody didn't tell him about a bond condition? In every case, you cannot have any contact with the victim of the offense. If you're doing that, your bond is revoked. You stay in jail until this thing gets done. But the bondsman told you that. You got the bond conditions are normal for everybody. It's the same. No matter who the victim is. If it's your wife, tough. Y'all got to separate until this can get resolved. You're not supposed to assault anybody, much less a wife, but you can't have contact with the victim. Why are you looking like nobody? Your attorney didn't tell you this?
I understand it, but
Your bondsman didn't tell you this? Of course they would have.
the bondsman told me that the protective order took precedence over the
I don't care what, not in my court.
Yes, sir.
Protective order doesn't bind me. This is my order. It has its effect. Protective order, I don't care. What's the protective order say? Not to have any contact with him?
Protective
Well, what
order
are you doing? You're breaking 2 orders?
Your Honor, the protective order stated for me not to go in 200 yards on my wife or the children, but the protective order lost its effective date on October the 1st. The CPS caseworker asked her if she wanted to extend the protective order.
Okay.
She told him no.
Okay, that doesn't matter to me. My order stands. It's the same order that's in every case. I'm sorry, aggravated assault with a deadly weapon. If you happen to, once you do something, you break through the barrier and you do an act, you're capable of doing it, the same act again, no matter what you want to say. You shouldn't have done it the first time. If you did, you're presumed innocent. I don't care. The point is the grand jury thinks otherwise.
Yes, sir.
They heard evidence and probably you committed the crime. That's probable cause to indict. But the point is we separate the victims. If it happened again, twice, it would be on my watch. Yeah, people would ask me.
It won't happen again, Judge.
You know what? If I would have asked you the day before you were accused of this, if you'd be charged with a crime like this, what would you have told me?
I'm not sure.
Oh, really? I can tell you what I'd say because I'm pretty certain about my actions. I mean, assaulting someone is pretty clearly wrong. And I can tell you, I wouldn't do it. I've never done it. But the point is we separate people. My court order is you don't have any contact with her. I find you do. I find out you do. This should have been told to you, and I'm aggravated about it because this shouldn't happen. Because if something happened now, I'd be the one going, you're not policing your orders, are you?
The reason why.
You know what? Failure is not an option. There is no reason.
The reason why.
There is no reason. My order stands, sir. Do not have any contact with this lady. And that's the order for everyone who has victims in their indictments. They have to stay apart until we can resolve this. Because it's happened before and it's in before people have gone right back and assaulted the same person again. And then they go, how could this happen? if the court was policing his order properly. And these orders are the same. These are the same bond conditions in every case. It's not my special order. The judges all use the same standardized bond conditions. And one of those is don't have any contact with the victim until we can resolve this. You got to figure it out. Either you leave or she leaves. I don't want it. And I'm going to check on it. May have somebody drive by every day if I have to find out if you're violating the order. You do, you'll sit in jail. Your bond will be revoked. You'll sit in jail until we can get around to resolving this, which sometimes takes years.
That's hard to do.
Sir?
That's hard to do. I mean, the reason why I'm saying that is because
You've got to figure it out, sir. Well, just like every defendant has to figure you got a problem, fix it. You got an attorney, work with your attorney. That's what he's paid for, is to help you resolve this. Everybody makes mistakes. And you're presumed innocent. We're not saying you did. You're charged with making a mistake. If you made a mistake, fix it. Fix it. Yeah, people make mistakes. But number one, you fix it. Number two, you don't do it again. Okay? But you got 24 hours you got to work with him.
I'll talk to him about that, Your Honor.
I mean, that's serious. Because we've had situations where partners, married people, partners came up here. We had an assault and they went right back, got together, and someone was killed. And then it was, who's to blame then? Bondsman, and most importantly, the person who does the act. But this is to separate, time out, get everything fixed up so we can get back in the game of life. It's in everybody's best interest. But and then a lot of times is we find out a lot of times in these partnership things that people are threatened, they're intimidated, they're back together. They're not supposed to be, but one or the other feels like they didn't have a choice. They're pressured into it. And that really makes me angry. Then wrath comes down because all kinds of problems develop that need to be fixed quickly when that happens. Because I don't want victims feeling like they're to blame. That's needs to get fixed. How long have y'all been married?
Going on 4 years. Been together for 9 years, going on 9 years.
You got a copy of this, don't you? This is one of the more disturbing probable cause affidavits. The most threatening thing I've heard, between threatening with a gun, punching, hitting.
Your Honor, that's one of the reasons I was trying to get him in the Veterans Court, because a lot of this relates to his.
When's that going to happen, John? He's staying with the victim.
I know. I'm going to work on that to get him out.
You think? It's got to be done today. Something.
But he's getting treatment to the VA's office right now. VA's medical.
Oh, I'm going to say while we're getting around to doing it. Look, this was indicted August. How much time has to lapse before the rules are followed? Come on.
I'm going to talk to him about that to make sure he follows the rule, because he was following the rules.
And I want to know who's going to accept responsibility if something bad happens. Is it you? I just found out about that. Y'all have to be knowing. State, what are you going to do about it? We got a violation of condition of bond that's being violated here. And I mean, this is this threatening with a firearm, threatening to kill, punching in the head, choking. My God, that's what this all says. And we're lackadaisical about separating this.
No, sir. We've asked for his bond to be revoked. I just found out. I was not aware of this, okay. So I'm certainly not going to be.
We got 1,000 cases. I'm surprised that you're not aware of everything.
But I would ask that his bond be revoked.
I say we have him separate now, make sure he doesn't have any contact with it from here on and, see how that
Yeah.
goes.
You've just been ordered to have a electronic monitoring device, a GPS device. So I know where you are because you're not going to go to this house
Can he have some time to go get his stuff and move out though?
without her presence.
But he
Somebody's got to watch that.
But he would have to contact her to let her know.
You have a problem working with them on that?
No, I can do that. I'm saying that,
well,
but I know the rule
because
is
somebody,
on his behalf.
I expect somebody, I can trust you.
Okay, fair.
Please.
That works. Okay.
And you have to have a GPS device. You can't have contact with this lady until we can resolve this. Is this just, I know I'm making a big deal. It's only very disturbing. This bad things can happen under these situations. And then we got orders, conditions of bond, and the court orders that are for every case like this that have to be followed, or else something bad happens. It will be front page. Who's to blame? And I don't think he'd be the first one on the name. He'd be in the list, but it would be someone else would be at the top. I don't want it to be me, but I expect the orders to be followed. The point is right now I could revoke your bond. I can hold you in contempt, and I could say no bond until this gets resolved. That's what can be done right this minute, from what I know. Tell me why I shouldn't do it.
I think we need to give him a chance, Your Honor. I think he understands now. Like I said, I will set up, call his wife, let her know that he needs to get his stuff. We'll set up a time for her not to be there to get that stuff. And you were living with your mother at one point.
I want
You have a place to
you got a week. We're going to reset this in a week to find out whether there's a problem or not, and if it's not done immediately, and I didn't find out it was done by the end of the day, then you're going to go to jail.
Okay.
That's
what by the end of the day?
My order has to be followed.
Oh, I know, but what if we can't get her stuff out today? Can we do it tomorrow? I mean,
somebody has to, but you can't have contact with her.
We have it set up where she's out of the house at a certain time and he go get her.
Okay,
but it doesn't have to be done by
but
today.
she's living there.
Yes, she's living there.
Okay, y'all got to work that out.
All right.
But I just expect it to be done.
I will, just in a reasonable.
This is serious stuff. This is.
We won't have any more contact with her, but as far as him getting his stuff, we'll have to work out a time that's convenient for everybody.
I mean, that's a serious probable cause affidavit. That alleges some very serious violence. I mean, everything was listed in there: punching, choking, threatening with a gun. My God. Okay, we got to take this more than serious. This is deadly. I want a hearing next week. Okay, see what.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. She's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go. I have no patience for that. And trust me, after the day, I'm sitting up here, I'm the one that needs a drink.